Get started in 1 minute.
Good evening and welcome to the July 5th, 2025, August 5th, 2025 Joint Brookings County and City of Brookings Planning Commission meeting. This meeting is being recorded, televised, and viewable on Swiftel Channel 19, ITC Channel 168, or the Brookings County YouTube channel. I now call this meeting to order on the county side. First item on the agenda for us is approval of the Joint Planning Commission meetings. Is there a motion?
So moved.
Motion by Kyle Vanderwall, second.
Second.
Second by Darrell Kleinjohn. All in favor?
Aye.
Motion passes.
Good evening, everyone. We'll open the city side of the Planning Commission. Is there a motion? Second?
Second.
All in favor?
Aye.
Did you do the minutes?
Yeah, do the minutes too.
Is there a motion to approve the minutes from the June 3rd, 2025 meeting? Sorry.
So moved.
All in favor? Motion passes.
Moving on, agenda items to be added to the agenda by commission members or staff. Nothing?
Nope.
Invitation for citizens to schedule a time on the commission agenda for an item not listed. Got nothing? Disclosure of conflicts of interest, relationships to the applicant, or ex parte communication. Seeing here none. Approval of agenda. Is there a motion on the county side?
Make motion.
Motion by Jensen, second.
Second.
Second by Troyan. All in favor?
Aye.
Motion passes.
Motion to approve the agenda on the city side?
Second.
All in favor?
Aye.
Motion passes. Thank you.
We will now convene as the Joint County and City Planning Commission. The Planning Commission of the County of Brookings and the City of Brookings consists of both Brookings County Planning Commission and the City of Brookings Planning Commission members. The concurring vote of a simple majority of those Joint Planning Commission board members present and voting is required for the recommendation to the Brookings County Commission and the Brookings County City Council for the final decision of the rezoning request. Agenda item 2025 JJRZ003, Ostream Investments LLC by Andrew Ostream has made an application 2025 JJRZ003 to the Brookings County Planning Commission for the property to be rezoned from joint jurisdiction business B3 heavy district to joint jurisdiction industrial I1 light district. The property is described as the northeast 1/4 of the northeast 1/4 excluding lot H1 and that part lying east and north of Lot H1 in Section 14, Township 109 North, Range 50W, Murdary Township, located 21625 471st Avenue, Brookings, South Dakota 57006. Is there a motion on the county side?
So moved.
Motion by Paulson, is there a second?
Second.
Second by Kyle Vanderwall.
Is there a motion on the city side? Thank you.
Richard, would you read staff report?
Yes, I'll, as long as I'll turn the staff report over to Ryan for the city side, as long as it meets the city requirements, the county has, as far as the county development side, we have no objections to it. So Ryan, I'll turn it over to you.
So from the city side, Ostreim Investments LLC, they purchased this property and rezoned it back in 2021 from ag to business B3 heavy business district with the intentions of opening a contractor shop, developing a contractor shop down on the property for their excavation business. The city recently updated some zoning ordinances to address rock, concrete, asphalt crushing. We defined it, and we defined the districts that it would be allowable in. On the city side, it would be allowed in an I-1 and I-2 district, as well in ag districts, as we allow gravel mining operations in the ag district. In this particular case, Ostreim kind of got caught in a pickle there, in that portion of their business is the concrete crushing, and it is a sustainable reuse of spilled concrete. It works really well in the construction industry for base course for roads as well as building sites. However, it is a conditional use in the I-1 district. The applicant is simply trying to rezone the property to I-1 and then pursue a conditional use so that he's in compliance with the zoning ordinance. And so the first step in the process is to seek the appropriate rezoning to I-1 so that he makes sure that he's compliant with the zoning ordinance for the city of Brookings, because it is within the joint jurisdiction area. Staff does support the rezoning request, and we'd stand for any questions you may have.
Thank you. Is the applicant here? Want to step forward and clearly state your name into the mic, make sure the green light's on.
I'm Andrew Ostreim with Ostreim Investments, I guess. Mike pretty much covered everything. We're not trying to do anything different. We're not reinventing any wheel. We're just trying to stay compliant with the ever-changing ordinances, I guess. So if you have any questions or whatever, I can answer. But
Is there any questions from the county side?
Any questions? City side?
You can go back to your seat for a minute. Moving on, we'll move to the public hearing portion. Is there anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public hearing portion. Move back to the board for additional comments or questions. Any additional comments or questions on the county side?
Likewise.
Mr. Chair, just one question. I think this is for staff. There's a note in the item here that the property is open wetland on the future land use. Is that just, this was before we really got going with future land use amendments, and this will just need to be cleaned up at some point?
Yeah, on our comprehensive plan, it does identify this area as open space wetlands. It got rezoned kind of before we started a lot of that process with updating the future land use map. It is already existing zoned property as a B3, and so we don't oppose it for that reason.
Thank you.
Any other questions? Seeing none. Richard, would you call the vote on the county side?
Yes. Yes, Kelly Vanderwall.
Yes.
Paulson.
Yes.
Clark.
Yes.
Kleinjohn.
Aye.
Kyle Vanderwall.
Aye.
Storhog. Troyan.
Yes.
Jensen. Yes. And Ford.
Yes.
Motion passes on the county side.
Ryan, would you call the vote?
Limmer,
Yes.
Spear,
Yes.
Heinrich, Braun,
Yes.
Solom, Aiken,
Yes.
Letty.
Yes.
Motion passes.
Thank you.
Moving on the county side, is your motion to adjourn?
So moved.
Motion by Cavender, will second. Second by Jensen, all in favor?
Aye.
Adjourned on the county side.
Likewise, on the city side,
So moved.
all in favor?
Aye.
Aye.
Meeting adjourned.
We'll get started in 30 seconds. Dale, you can sit up front. Dale, you can sit on the board.
I will, but then Luke will come in and screw everything up. The longer I talk, the less he gets to. Good evening and welcome to the August 5th, 2025 Brookings County Planning and Zoning Commission meeting. This meeting is being recorded, televised, and viewable on Swiftel Channel 19, ITC Channel 168, or the Brookings County YouTube channel. I now call this meeting to order. Approval of minutes. Is there a motion?
So moved. Troyan.
Motion by Troyan, second?
Second.
Second by Jensen. All in favor?
Aye.
Motion passes. Items to be added to the agenda by commission members or staff. Just our regular staff report. Okay. Invitation for citizens to schedule a time on the commission agenda for an item not listed. Seeing and hearing none. Disclosure of conflicts of interest relationships to the applicant or ex parte communication. Seeing none. Approval of agenda. Is there a motion?
So moved.
Motion by Jensen. Second.
Second.
Second by Kelly Vanderwall. All in favor?
Aye.
Motion passes. We will now convene as the Brookings County Board of Adjustment. No, wrong one. I knew I was going to do that. We will now convene as the Brookings County Planning and Zoning Commission. The Brookings County Planning Commission is a 9-member commission whose function is to recommend approval or disapproval of land use plans, zoning ordinances, subdivision plans, and amendments thereof to the Brookings County Commission. The commission makes its recommendation based upon the adopted comprehensive plan for the physical development of the unincorporated areas of Brookings County. As a matter of policy, all motions are made in a positive. After a motion has been moved, it is seconded and is open for debate. Those supporting the motion shall in turn give their reasons. Those opposing the motion shall then offer their reasons. After everyone has been given a chance to be heard, the commission shall recommend approval or disapproval based on the testimony and information presented. A simple majority vote of a quorum of members of the Planning and Zoning Board in attendance is required to forward a recommendation. Agenda item 2025, Plat 017, Plat of Block 11, Birkeland Edition, located in portion of Government Lot 2 in the southeast 1/4 of Section 29, Township 109, Range 50W of the 5th Primary, all in Brookings County, South Dakota. Is there a motion?
So moved.
Motion by Kyle Vanderwall.
Second.
Who had that?
Paulson.
Second by Paulson. Richard, would you read the staff report?
Yes, 2025 Plat 017. Mark Birkeland has submitted a plat for Block 11, Birkeland Edition on the west side of Lake Campbell, located in the Lake Park zoning district. Block 11 is 1.4 acres, exceeding the 20,000 square foot requirement and meets the non-lakefront setback requirements of 25 feet on the front yard, 25 feet on the rear yard and 8 feet side yard. The preliminary plat was approved on December 3rd, 2024, and meets the requirements of the Brookings County subdivision ordinance, the Lake Park zoning ordinance, and the 2016 comprehensive plan. Unincorporated use for development lakes on page 11. This is the plat, block 11 right down here on the road. There's the beacon map with the plat overlay on it at 468th and 219th Street, and otherwise known as Lakeshore Drive going to the east. This is the beacon map. This is where the proposed plat would be located. That's all that I have, and the applicant is here this evening.
Do you want to come forward and say anything or not? It tells me to ask you to come forward and state your name.
I'm Mark Berkland, and want to plat that, get the final plat on that block.
Do you got anything to add to Richard's report? Any questions from members of the commission? You can go back to your chair.
Thank you.
Move to the public hearing portion. Is anybody in the audience that is for this? Excuse me. Seeing and hearing none. Is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll now close the public hearing portion. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Paulson.
Aye.
Clark.
Aye.
Kleinjohn.
Aye.
Kyle Vanderwall.
Aye.
Dale Storhog.
Aye.
Neil Troyan.
Aye.
Jensen.
Yes.
Kelly Vanderwall.
Aye.
And Ford.
Aye.
Motion passes.
Moving on, agenda item 2025, Plat 018, Plat of Fuller Edition and Government Lot 2, Section 15, Township 109 North, Range 47W of the 5th Primary Rating, Brookings, South Dakota. Is there a motion?
So move, Paulson.
Motion by Paulson, second.
Second.
Second by Jensen. Richard, would you read the staff report?
Yes, 2025 Plat 018, Sochi Enterprises by Rick Brownlee have submitted a plat of the Fuller Edition in Government Lot 2 of Section 15, Township 109 North, Range 47 West. It's a 16 and 7/10 acre parcel. It's being split off from the 38.79 acres that they own. The 16.07 acres was a former gravel mining area, with the balance of the property being farmland. The property borders the South Dakota-Minnesota state line, and the adjoining property owner in Minnesota has a purchase agreement on the proposed plat. And there is an ingress and egress access easement on the noted plat that is recorded in document number 2025-00541 in the Lincoln County, Minnesota Recorder's Office that will provide access to the property and does meet the platting requirements of the 2016 comprehensive plan on page 24 for the agricultural land use. This is the plat. This is the 16 acres right here. This is the South Dakota-Minnesota line. This is the access easement going in on the Minnesota property that is recorded in the Lincoln, Minnesota Recorder's Office for access to Track 1 there. Here's the beacon map with Track 1 of the plat laid on it. Basically the mined out area there is what he is purchasing. Here's the beacon map showing the long, I believe it's 79 acres, so there's the balance. There's the plat that is being platted off, and that's all that I have, and the applicant is not here this evening.
Thank you. If the applicant is here, we'll move to the public hearing portion. Is anybody in the audience that is for this? Seeing and hearing none, is there anybody in the audience that is opposed to this? Seeing and hearing none, I'll close the public hearing portion. Any additional comments or questions from members of the board? Seeing none, Richard, would you call the vote?
Clark.
Aye.
Kleinjohn.
Aye.
Kyle Vanderwall.
Aye.
Troyan,
Aye.
Storhog,
Aye.
Jensen,
Yes.
Kelly Vanderwall,
Aye.
Paulson,
Aye.
and Ford.
Aye.
Motion passes.
Moving on, agenda item 2025, Plat 019, plat of Block 1 of Roland Hutterite Brethren Cemetery Edition in the southeast 1/4 of Section 9, Township 110 North, Range 48W of the 5th Prime Meridian, Brookings, South Dakota. Is there a motion?
So move.
Motion by Kyle Vanderwall, second. Second, Cody Clark. The applicant is not here, so we'll move to the public hearing portion. Is anybody in the audience that's opposed to this?
Would you like me to give my staff report?
Oh, hey, I should do that, huh?
2025 Plat 019, Roland Colony by Lawrence Whiff is platting off an 8,100 square foot area, which is 0.18 of an acre, that is being used as a cemetery. The original footage description of the cemetery for the properties was deeded off in 1991, and this past year it was determined that the footage description that is on the deed is not the actual location of the cemetery. So the plat reflects the correct location of where the cemetery is located at this time, and the plat meets the requirements of the comprehensive plan on page 24 for the land use. Here's the plat showing the cemetery there. The blue square is where the legal description that was recorded in 1991 was located. This is where the actual cemetery is located, in the red square, with that being the plat of Block 1. So to get things squared away, they're replatting this, and they'll do some other deed work to get this cemetery back to the colony, and then the colony back to the cemetery with the new location and legal description. So that'll be on their end to take that. But yeah, right now, this is the beacon map showing where that was on the deed, the yellow square, and this is where the actual cemetery is located right here. And that's all that I have, and the applicant is not here this evening.
Thank you. Since the applicant is here, we'll now move to the public hearing portion. Is anybody in the audience that's for this? Seeing and hearing none, is there anybody in the audience that's opposed to this? Seeing and hearing none, we'll now close the public hearing portion. Is there any additional comments or questions from members of the board? Seeing and hearing none, Richard, would you call the vote?
Klein John,
Aye.
Kyle Vanderwall,
Aye.
Storhog,
Aye.
Troyan,
Aye.
Jensen,
Yes.
Kelly Vanderwall,
Aye.
Paulson,
Aye.
Clark,
Aye.
and Ford.
Aye.
Motion passes.
Moving on, agenda item number 9. Board training by Luke Moeller from First District Association of Local Governments.
Hi, everyone. I am going to plug my computer in and try to run from here. That'll be a lot easier, so I can bounce around on stuff. We are basically going to pick up where we left off, doing training, was it July or June? I don't recall. It must have been July. Wonderful. Now we're there already, and I will get flying here. It's not my plan to go over what we already did, but we just will pick up where I left off the last time. So I'll spare you the introduction, spare you the what we do, because you heard it before. By all means, you want to argue with me or tell me that I just don't get it because I sit here and I tell you, and you guys sit there and live the life, by all means, go ahead and do so. We'll have fun and discuss it. Honestly, it helps to have some of those stories. But I'm going to go through here, picking up somebody trying to get a building permit and working our way through what we talked about was a discretion pyramid. I know I showed probably about the first 3 or 4 slides last time, but I went full-on auctioneer mode as we were finishing things up. So I want to get through this a little bit. We start with the concept of getting a building permit. This is essentially, I'm going to say a poor display of a diagram, but nonetheless, these are the decision-making tree of what goes on through your zoning officer when issuing a building permit, okay? These are the questions that need to be asked. And in some of those cases, obviously, they reach points where it's a no. And when it's a no, and they're in the zoning officer's standpoint, then there's the other points. Review the use, is it something that can be rezoned if it's a no? Or is it a listed use in the district they're in? No, well, can it be rezoned? That's the step. Person can ask you guys if you're interested in amending the zoning ordinance, and you can see that process and going down. If you go into, if it is an allowable use, well, is it a conditional use or permitted use? If it's going to meet one of those couple of them, does it meet the setbacks? And so on. You can somewhat see that decision tree, but the bottom line is, it is a lot of decisions and pitfalls that can come in. In this, the planning pyramid that I showed in previous times, if I work from step one as a building permit or all the way to the bottom, basically, the bottom of this pyramid has more discretion, it's more legislative actions. As I get all the way to the top, it's what we call ministerial. Ministerial is a thing that, simply put, one, remind you, not an attorney, this is a guy who does this a lot. Building permit is largely ministerial acts, however, there are some interpretations that the zoning officer has to make. A ministerial act would be just a thing that brings about an application. Basically, in order someone makes an application and meets all the requirements, I'm signing the application. That's a ministerial act, for lack of a better phrase. There are interpretations that have to be made whether or not the thing they're building meets the definition of a fence. Do they need a permit for this thing, that sort of thing. Working your way down, though, variances have less discretion. It's more judicial. You're boxed into a corner as a board of adjustment, but you are the board of adjustment, you're judge and jury. Conditional use, you've got more discretion because you're effectively assigning conditions that are on a case-by-case basis, but largely that is identified as a thing that can be used. Moving on, as far as plats and subdivisions, you have lived this life largely, so you're aware of the fact that you got more discretion when it comes to a plat. Hey, why not move the lot line over here? Is this the right place for a road? Does it meet what our land use plan says? Zoning ordinance, generally we would want, from a standpoint, again, it's discretionary. You're setting it up to go the best way to make it there. I really went into detail on the building permit, but I talked about this because we asked a question last time about issuing variances. Talked about them at the lake, but I do want to get into this a little bit about what a variance is, because there's some key components here that really, again, to hammer home the point that if you find yourself issuing a lot of variances, you need to look at whether or not the rule is right. Are we making criminals out of people that are following the law or not? Or what is this rule really based on? One of the things that, like we said, Board of Adjustment has the ability to hear, authorize variance from the terms of the ordinance owing to special conditions. A literal enforcement creates an unnecessary hardship, okay? Most counties have something similar to the language here that says that the Board of Adjustment shall have the power where, by reason of exception, narrowness, shallowness, or shape creates exceptional topographic conditions or other extraordinary and exceptional situation or condition, allows a variance without substantially impairing the intent or purpose of the ordinance, meaning that there is something so unique on this property that we didn't think about it when we wrote the rules. There's a cliff. There's oftentimes floodplain isn't a bad example. That's a decent example. If there's a floodplain or river changed its course or something like that, or the property line, all of my property's over on this side of the road because, you know, they lobbed a township road in between there. Those are odd things. Pretty sure I told this story the last time, so I'm not going to get terribly far into it, but basically what I said before, if it would be easy in many cases to take that easy way out, right? To just say, it's not a big deal, it's 3 feet. This is the 15th time we've issued this variance to let them be 3 feet closer to a property line, whether it's this person, that person, the next one, so on. Let's just issue it and be done. What you really ought to do is go, you know what, this is the 15th time. This rule clearly is not the rule. The norm is to be 3 feet closer. Let's amend the rule. Technically, you should hit timeout and do that. What I do see places do is they do a year-end review and take a look at, well, here are the variances we issued this year. And that's consistent with the year before. So maybe we ought to look at amending the ordinance to address that. The example that I used, of course, was the one-way going the wrong way and then just changing the rule to go two-way traffic. That fixes the problem. Same is true. Look at it. Is there an easy fix? Then you can figure out in that discussion. Oftentimes you'll lead to, oh, that's why we had that rule. It was this thing or that reason why we have this rule. Or you'll go, I really don't know why we had that rule to begin with. Let's decrease the setback. Let's make it so that you can have a greenhouse in the rural Lake Park district, whatever it is. I don't know why that rule was there. So it's one of the things that comes up. But here's variances in plain English, okay? Someone's asking for a variance. They're asking to break the law. It's just that they've got the common courtesy to ask permission first. That's really the only difference. It would be, it's similar to you calling the police officer on Thursday, telling them you're probably gonna wake up a little bit late and you wanna drive really fast on the highway tomorrow. There may be excuses in where you can do that. Better be an expletive deleted good reason though. Better be a damn good reason that's going on there. And there are those reasons out there. But the burden is on the applicant to explain why they should be able to break the law. The courts tell us that because it costs more is not one of those reasons. And then, as I said, periodically review those variances. So everybody has about the same 4 to 6 steps questions that you're gonna follow in there. And I just highlighted the key words in there because they come up often. But special conditions and circumstances are peculiar and are not applicable to other properties, buildings, whatever, in the same district. Next one, the literal interpretation, deprive rights other properties have in the same district under the terms of the ordinance, meaning that it keeps me from that ability. That's one that oftentimes is cited as a reason why they should be able to. Well, my neighbors have this. Well, they got a bigger lot. They got more room, that sort of thing. Or it was used, I just want to see, do I have it? Yeah, we'll get there. Or it was a non-conforming thing. It was built before we had ordinances. Well, just so happens that that's written in case law and that no permitted or non-conforming use shall be grounds for the issuance of a variance. So just because someone else had it before the zoning ordinance was there is not grounds to issue a variance. The other one that's out there is they don't result from actions of the applicant or the property owners previous to them, because again, we're dealing with running with the land. The variance doesn't go away when Tim moves off of his property. It carries forward with the next property owner, so it stays with the land. It will not confer special privilege that is denied to other properties in the same district by doing so. You're not giving them a benefit you wouldn't give to everyone else or that they don't by right get. It's the minimum, and it needs to be in harmony, not injurious, and otherwise detrimental to the public welfare. So I think what's really important to remember when you're talking about variances, though, is that if I hit one of these, that's cute. I got to hit all 6 of them. These are not or statements up here. These are and statements. It's this and this and this, but not this. It's this all the way through. So they have to meet all of these. So there are many times, like I said, that someone's asking for a variance for, say, again, we'll just go back to a 10-foot variance on the front yard setback. You look up and down the road, there's 3 other places that already have that setback on there. They also have the same size garage that this person is asking. But all of those were built before we had zoning. Well, we can't use the nonconformity as the reason. What else do we have out there? Well, is it super duper, is it more narrow than everyone else's lot? No, it's the same size as everyone else's lot. So we can't use that. Well, that pretty well should shut it down right there, because it's the same size as everyone else's lot at that point. And so when writing the ordinance, it is assumed that you took that into account. If you didn't take that into account, then, okay, well, if there's a lot that's this size, maybe the setback should be less. Okay, there you got your exception, and you can go on. Those are things I want you to think about as you're going through. Now, this is the rah-rah speech, deny more variances, but you are going to see cases come in where you've issued them before. You do have to avoid being arbitrary, but in the same breath, you do have the ability to be smarter today than you were yesterday. That comes from a Supreme Court justice. I want to talk about court cases that got us to where we are on variances, okay? And I'm going to bounce to a different presentation because it actually did a little bit better job in explaining it here. Should be about the same slide though. Okay, let's open it. Really? There we go. All right, so there's a lot of case law on variances, and without getting too much into all of the cases and giving you story time, here's basically what I want you to keep in mind, okay? Once we've gone to court on these are the ones that get referenced the most. At least there's a couple of oldies but goodies. That's Madison versus Clark in 1980. They established a 3-step test at the Supreme Court. Will granting the variance be contrary to the public interest? Did the applicant show that special conditions exist under which a literal enforcement would cause unnecessary hardship? See how they combined about 3 of those points, maybe even 4 in that? And so they combined a bunch of them into 2. And then 3, will the spirit of the ordinance be observed and substantial justice be done? Those 3 were clung to in that case to say that it's the job of the applicant to prove these things at the meeting. It's not the job of staff. Staff, in the same breath, is going through saying, here's what guy wants to do, here's what the guy wants to do, here's what the ordinance says about it, here's your history on these things. Good luck, board. That's generally what we're doing in that case. Hines was another city case that carried forward those steps 1 and 2. It basically just reiterated that 1 and 2 are really important, but it wasn't as heavy on that 3rd one that was above there. Probably the most important thing to keep in mind, though, is that also reiterates the point of a term that I'm going to butcher because I'm from South Dakota and I don't speak Latin, but it's a writ of certiorari. That is the standard under which variances, Board of Adjustment items are reviewed. And I'm not just going to tell you a term, I'm going to tell you what it means. The writ of certiorari basically means that you're being reviewed as to whether or not you followed your rules. When the judge hears a case that's appealed on a variance or a conditional use or even an appeal, the judge is reviewing whether you followed your rules, not whether or not you made the right decision. So I want you to think about that. They're not rehearing the case. They're hearing whether or not that however many page zoning ordinance you have was followed. And then, oh, by the way, state law too. So they're reviewing whether or not you followed all of that. So that's why it's ultra important when you're issuing variances, and then we're going to talk about conditional uses, that you follow the zoning ordinance in doing so. Because, fast forward all the way, 21 years, there were variance cases that went in, and a lot of times they wind up by lakes, go figure. But there were variance cases that went through, but they kind of reiterated the same things. But we had a flurry of them here in 2025, early this year, that were appeal after appeal. And rather than get into, I've got all sorts of details on these in the other slides, but I think it's just worth noting. In this one in McCook County, that was right ahead of the one for Lake County, the Supreme Court determined that a lower court circuit court should review the findings of fact to determine whether step 2 was followed, meaning, did the applicant show special conditions exist under literal enforcement? Before, what the argument was that, no, you're rehearing the case if you look at my findings. And what that case did is said, no, we have to look at your findings to make sure that those 5 things that I read previously about owing to special conditions, doing that, the things that are in your ordinance as well as the decisions of previous case law, that you actually went through the due diligence and you made findings on those things, okay? So that's what that case is. You do that. Your standard practice, you guys do that, okay? But not only do you have to reiterate and find that they met those, Dunham versus Lake County, which was shortly thereafter, said that not only do you have to recite the fact that you did that, you also have to cite things that prove that as well within the application. And again, you guys do a pretty good job of that as well. What's important is that as you're going through and reviewing these, like as Richard's reading the findings of fact, and you're concurring with them or whatever, make sure you've got something that's within there that proves that, yes, they did demonstrate that there are special conditions. Here's a couple special conditions on the property that we don't see every day. And it does create an unnecessary hardship. And then also that granting the variance won't be contrary to the public interest, which is one of your standard findings. Because what happened in Lake County was they had kind of the standard findings, but they didn't go any farther. They just had them and said, yep, we hereby find that they met section 1, section 2, section 3, and they recited them. Here you go. Here's your findings. Well, ultimately what happened was they reheard it and then they put in how did they meet them. It was one of those, well, we know what the answer was, but we didn't write them on the paper. You need to put them down as far as how they did that. And so I just want you to understand that that process of putting those findings together is ultra important, the reasons you issued that. So the takeaways and best managements on variances are that decisions need to be based upon the application of the regulations. Very rigid, okay? Must prove an unreasonable hardship to receive variance. Standards for variances, I'm reading these out loud to you, but equal treatment is essential, so don't be arbitrary. If it's good for this one, it's good for that one. So the more findings or the more specifics about this case, the better. Otherwise, be ready to be amending your ordinance. And then there's a couple other points, okay? The bottom ones. Only issue variances for rules your ordinance defines as varianceable. What does that mean? Not everything is varianceable. You can't variance every single thing in your ordinance, specifically uses. You can't have a variance to allow a use that's not allowed in a zoning district. An argument has been made, and it's a very good one, that if we have specific conditions into a section of, say, a conditional use permit, and we have specific conditions that say that a campground has to have at least this many spaces, or vice versa, a campground can't have more than this many spaces. That's the cap. It's done. If it has more than that, it's a use variance, because they're asking to do something outside the scope of what we decided. If we want to allow them to do that, we got to amend the ordinance. We can't do it on the fly at a hearing. There's an argument been made. It hasn't been taken to court, but I think it's a good one. And so some of those into there. That's why when you adopted the update to the zoning ordinance, I'm going to use the example of feedlots because that one sticks out in my mind. You wrote in exemptions that you have to be this far from a house unless the neighbor signs off. Okay, neighbor signs off, that rule, we don't have to account for that rule for that specific house. You gotta be this far from a road unless the road authority's cool with it. You've got to be this far from a well unless it's your own well, things like that. Okay, so you write those exceptions into there. And sometimes when you run up against one you didn't think of, they got to hit pause and go back and you ask whether or not that works for the whole county. So are there any questions? And then the other thing is, used to do variances to sidewall height, things like that. That's not a varianceable thing. It's just either that's the max or it's not. There's no hardship. There's no hardship that's gonna say that I need to make a wall that size. You used to list it as a conditional use, which was better. In fact, I think you still do. But a variance itself, no. We need to write exceptions into there if that's what we're gonna do. Going back, any questions on variances? Do you wanna talk about? Or do you wanna talk about war stories or horror stories? None so far? Okay. Let's talk about an appeal. And I really only want to get through appeals and conditional uses for the most part here tonight, so just for what it's worth. Appeals you haven't seen many of, but an appeal is the way that the zoning ordinance is set up. All the questions come to the zoning officer, okay? Every question of interpretation comes to the zoning officer. So an appeal is where it's alleged that that zoning officer made a mistake, that zoning officer doesn't know their ordinance, that your zoning officer who's been doing this for 10 years? 10 years, but has closer to 25 years of experience, knows less than the person who made the application. 25, 50, however long it's been, Richard. So they're appealing to you as the board, hey, they don't know what's going on. I've got this fun little cartoon strip that I think I'm going to do a better job of later, but basically, they ask the administrative official a question, they disagree with that answer. Within 21 days, they come in and they file saying, nope, you're wrong, I'm going to appeal you to the Board of Adjustment. They have to be an aggrieved party, and there is a definition of an aggrieved party. I'm not going to get into it other than it's defined in state law. They have to be qualifying. One of the things that we were running into there for a while on aggrieved parties where we were having special interest groups or clubs coming in and filing that had no standing, they weren't a neighbor or something like that. So there's that. When they file that appeal though, it's not just, I think you're wrong. They're filing an appeal that you interpreted section 4.0304 of your zoning ordinance wrong, and here is my supporting information. Not, hey board, I really kind of want to have a concert venue in the Lake Park District and Richard won't let me. No, that's not it. Tell me the section of the ordinance I said was wrong. That's what that winds up having to be. The process on administrative appeals, you determine whether the question is ministerial. One of those good examples was we had this case in Grant County for years. That's where this question of ministerial came up, was a zoning officer made a change to the building permit application because she needed different information to answer questions or figure out if the zoning ordinance was being followed, and that got appealed, saying that I really don't know why it got appealed. Bottom line is it got appealed. I just know that I got deposed on it, and it never made any sense to me, but basically at that time they were arguing that only the county commissioners could change an application, which really made no sense. But it was a ministerial act to bring about an application. It was the way for her to figure out whether or not they were meeting this one rule that this question always came up. So, is the question of a ministerial nature to bring forth an application? Did they have discretion? Once they've determined that, that's usually an attorney question, then we set the meeting date. Publish notice at least 10 days prior. A hearing is held. You've had these before, only a couple. But the way that that works is you hear testimony from the appellant and then testimony from, oftentimes it's the county's attorney. Sometimes it's staff, but really the staff has just put together the report saying, here's what I told them, here's the rules. Pretty black and white. And then staff is there to answer questions from you. There's not a lot of deliberating there. This does require a hearing, but it's been explained to me from attorneys that represent through the Public Assurance Alliance that this is a hearing in the same way that magistrate court is a hearing. It doesn't mean that everybody who's got something to say about, why Luke should have gotten that ticket for speeding on Thursday, it doesn't mean everybody gets to get up and talk about it. I'm arguing my case that Richard was wrong. Richard is there to answer any questions on that. And if it feels like it's going out there, state your case, go on. And so it's not all comers. It's somebody filing on that behalf. The board then decides whether the administrative official or the appellant is right. One of the things that's unique is that you as the board, obviously, you know this in your bylaws, you always make the motion in the affirmative, right, before you take anything up. So in this case, your motion is to approve their appeal. So your motion is to say, that person, me, sitting in this chair is correct, Richard's wrong, okay? To get it before you, you're making the motion to approve the appeal by so-and-so, okay? So if you agree with Richard, or your zoning officer, if it's not Richard in how many years, you're gonna vote no. If you agree with the appellant, you're gonna vote yes, okay? You're not saying, was Richard right? You're effectively saying, is the appellant right with your vote? Is the appellant right? Yes? Yes, you rule in favor. No? No, you rule in favor of Richard's decision, okay? That's the one thing, and trust me, that's one of those where I'm gonna wind up in the room too to make sure that we keep that straight as well. But you wanna double check, that's why it's important to double check. What does a yes vote do? What does a no vote do before you're voting, especially on these things, okay? But that's one of the keys. It requires a 2/3 majority to rule in favor of the appellant. 2/3 majority of the full board, which is the same rule on variances as well, okay? So it's gonna be 6 members, whether there are 7 of you here or whether there are 9 of you here. Great, is that right? Yeah. So I just talked about that process. So with that, you guys had any appeals? You feel like I was wrong on any of that, or any questions on appeals? Because the last thing will be conditional uses, and then I don't know that anyone wants to be here much past 9 anyway. Oh, never mind, we're locked in. We'll be here all night. All right, no questions there. I'm just going to, I want to recap this, just kind of recap what your zoning districts have. You have use types. The use types are there basically because state law says that your zoning districts have to be uniform across the entire zoning district. Okay, that's why some places find it easier to have multiple different types of zoning district that are kind of the same, multiple commercial districts, some of them have multiple ag districts, so on. But you have permitted uses, things I can roll out of the bed and do. As long as I got 35 acres, I roll out of the bed and have a house, right? I can roll out of the bed and plant corn on that field tomorrow. That's a permitted use. It doesn't require you to walk through the door and get a permit, it's just blessed. In theory, we could require those, but it doesn't make any sense. Like, why would we make someone get a permit before they go plant corn? Accessory uses are uses that once you have one, you're expected to have the other. If I am farming, I am expected that I'm gonna have a grain bin, or a barn, or a corral, or a fence, or something like that. If I have a house, it's expected I'm gonna have a garage. Those are accessory. If I have a gas station, it's expected I'm gonna have gas pumps, things like that, okay? Special permitted uses are uses that are mostly permitted, except they've got a few specific conditions. For example, though they're not listed that way, your ordinance, we don't have any in your zoning ordinance, do we? We do. That's right, we do in the ag district. Those are ones, a good example, though I don't think we listed it this way, a good example is that lowest tier of feedlot, okay? They're listed as a permitted use, but there are specific conditions that they have to meet. Otherwise, I mean, you meet these conditions. And so that's one, but we have, what are some of them?
We had the Class C, mobile home for a family member
That's right.
is there. Setback for a non-ag structure, or for an ag structure. And shelter belts.
Yeah, that's right. What we're seeing these as much as anything for are those exceptions on variances and setbacks especially. Shelter belts, I think, makes a lot of sense, where I remember very specifically several times where this particular board said, if the township's cool with it, why are we in the middle of this in that case? I know that's it. I run into that in other places too. But those are examples where if they meet the conditions, they just get to do it. Move on. Conditional uses, those are the ones you're hearing all the time. You're familiar with them. They're subject to certain criteria and conditions. Prohibited uses are things that are not listed, so they're not allowed. One thing I do want to underscore with that point is sometimes uses are prohibited on purpose because we just flat out don't want them. And in other cases, they're prohibited because we didn't think about it when we wrote the ordinance. And that's why you can't really fault an applicant for asking, hey, is this okay or not? Did you guys really think about it? The one thing that I don't think members of the public realize is how much time going through a zoning ordinance is and how much, what about this? What about that? All of you that sat on that ag subcommittee know that, as well as within this zoning board. The process, notice has to be published according to state law at least 10 days prior. You guys do 14, right? You guys backed it down to 10. You've got 10 days. Adjoining property owners are sent notice prior to the hearing. Some places use signs, you don't. The city does. They use signs. Their decisions are based on the application to the regulations. Did they meet the requirements of the ordinance? All allowable uses to which reasonable conditions may be attached and factual findings. Basically, a conditional use is a use that's allowed in the zoning district, right? Seems obvious. That use is allowed in the zoning district. As opposed to the variance where no, unless there's a good reason. The conditional use is yes, unless there's a condition they're not meeting. And if there's a condition that you see, there's something very unique about the property, generally speaking, you got to give them a roadmap as to what is specific about that makes this not work. Because it's implied, if I walk through the door, that I can do that. I oftentimes will have somebody, when I'm in a meeting, you'll hear somebody come up and say, why did you approve it there? Or an applicant, I know that it meets the requirements, but why'd you pick that spot and not this spot, which might work better? It's like asking somebody, why didn't you keep looking for the remote after you found it? They already found it. They found one that met the rules. They found one that met the past application of your requirements. And they found one that pretty much met the same conditions. So why would they keep looking? They already found one. Sometimes they know that the neighbor's not gonna like it, other times they don't until they come in. So the bottom line is that if it is a no, oftentimes what you wind up seeing or hearing is that there's probably, it's not necessarily a no, it's that there's a specific condition that they're just either gonna refuse to meet or can't meet. And one of those examples is that I've got one where we've done it on gravel pits where if they're close to the interstate, we require them to reclaim as they go very little amounts. And sometimes they just say it's just not worth it for us because you're making us reclaim too fast. Okay, well, I mean, that's how we're gonna do it if it's close to there. We just gotta be consistent in how we're doing that. And I referenced that MG Oil case that's in there because that's where that comes from. There was a case in Rapid City in which it was a casino, but basically the the city denied a casino permit. It was a conditional use permit to a group wanting to have a casino. And at the meeting, they presented, you know, the neighbors, of course, said this is going to be a blight and it's going to be a problem and the police are always going to be there and it's going to decrease property values. And the applicant actually brought evidence of other casinos where property values didn't decrease. They brought police reports to show that actually in some of these areas that are similar to theirs where casinos went in, they didn't have more police reports. So ultimately, they wound up denying it. The city did. In their findings, they basically recited, hey, you weren't compatible. Because that's oftentimes what people say, it's not compatible. Your ordinance doesn't let you play that game anymore because you define compatibility as a justification for issuing conditions, not for saying no. But where that comes from is this case. Because in that case, the Supreme Court said, you can't just say, no, it's not compatible, especially when somebody brings a bunch of evidence to you that to the contrary. You better have some evidence too. So ultimately, they wound up throwing out the decision of the city and basically issuing them the permit because they ignored their own ordinance because the applicant actually demonstrated that it could be compatible. What they did say is that the Supreme Court said, you have to tell them what they missed so that they understand what is different about this. Because your ordinance does say you can do this. So there's clearly some disconnect. You got to say what that disconnect is, connect those pieces. So that's why in your ordinance you've kind of closed that loop a little bit and just said here that this is the grounds for conditions. So with that, I am fine calling that because those are the three duties of the Board of Adjustment. Appeals, variances, conditional uses. Okay? We talked about what a planning commission does, previous. The next time, probably the two most logical things we would talk about, spend a little bit of time talking about subdivision ordinances. I don't have a ton on that, but it's not a bad refresher, especially since you guys seem to be doing a whole lot of plats lately. Just kind of a refresher as to why you have that. And then also the importance, you guys have bylaws, but the importance of bylaws and following them, I think would be two short ones we could probably do at some point. And then the last thing is ex parte contacts, being a board member in public, because that's not easy for you guys to do, and I get it and respect you guys for it. So with that, are there any questions of me, whether it involves this or anything else?
One of the things you'd said is something about like a special interest group. So when we're in the public hearing portion of it, do we have to listen to everybody that's here for a public hearing?
Yes.
Or if somebody from Sioux Falls that has nothing to do with Brookings County?
Yes, you do.
Okay.
It is an advertised public hearing. Here's one of the things that we have done in other places, okay? There are two things that I was going to add when I was mentioning we should talk about bylaws. One thing we've done is we write into the bylaws immediately how long testimony is for. We say, if I'm writing the bylaws, I'll say that the applicant has between 10 and 15 minutes to talk, which is more than somebody in public has. Why? Because they're the ones asking the thing. And as we just went through, if it's a variance, they've got 7 things they've got to prove to you. If it's a conditional use, they could have 12 pages of zoning ordinance that they have to prove that they've met the conditions. So logically, it's going to take them longer. If I'm a member of the public, generally we'll go 3 to 5, depending on what the community is. And we just flat out put them in the bylaws. That way, you don't have to make it up as you go at the meeting, and you don't forget about it. That which would also be it. We don't pass timesies, things like that. But one of the other things we do is we require a sign-in, and we require you to mark whether or not you plan to testify. And we also require not necessarily an address, but where you're from. And so generally, in Cottington County, I can tell you the practice is, we call on people from the county first. And then the people from farther away can talk. Because we're most interested in what those people that are close to the applicant have to say. And then as they come in, not to say that we're not interested, because they might bring up something that was thought of somewhere else, but we're most interested in how that affects these people close by. And then going on, that would have gotten notice. It's a thing that you could look at in doing so, and then you just kind of reshuffle. It does put a burden on Richard and Bob or me or whoever, and Raylan, whoever's here, but you call people up, you don't say anyone else. Then you've got the sheets and you call them up. The one thing we do though, in that, and I know that you guys have had these large hearings where you wind up having everybody here and then there's someone else out there that didn't realize he had to sign up. At the end, and in our bylaws, we actually say this, everybody gets 3 minutes, okay? Everybody that signs in gets 3 minutes. If you don't sign in, you forgot to sign in, or you didn't think you were gonna talk, but I thought of one thing. That's the point at the end of the meeting, at the end of the hearing, before I close the public hearing. Is there anyone on either side that did not speak that has something to add? You'll have 1 minute after you speak after you introduce yourself. Because the people who did sign up, the people who followed the rules, should get to talk longer. And so that's how it's generally done. The other thing that I do when I'm calling people up, are there any proponents to this? And then the other group is opponents or neutral parties. Because that takes that, well, I don't really know if I'm opposed to it, but here are 7 reasons I think this is a dumb idea. So it takes away that I'm neutral and I didn't know, I just wanted to talk at the end. So it just kind of puts them all together in that standpoint. So those are a couple of best practices that I would do. And I would really do, one of the ways that we handle that is we have that sign-in sheet. You've already got the sign-in sheet. You just throw a check mark on it and then what item you're there for, right? You just take the agenda item, say, here's the agenda item, which agenda item are you here for? Just give me a number. And then from that, then the chair within our bylaws, the chair reserves the right, if there's less than a certain number signed up for it, reserves the right to just not call them by name, basically. Just say anyone else here. Because if there's only 2 people signed up, Monty, Steven, you don't have to go through that. So gives you that flexibility at that point. So that's an example that I really think about for you guys, especially as you roll into, you know, you're going to have another big one at some point. Lucky you. What's that? That's right. What else? Anything else?
I just think just to, even though you've kind of made your decision, just get in a dialogue or things that you like about the variance or why it's good or why the conditional use is. We had two former board members, they would just get up and converse and to the applicant, like say, yes, it's a good idea and why the board has their decisions and why it's there. And, you know, they could still tell them no in a nice way is what they're doing. But yeah, it gives the public a chance that we're just not sitting here and we're just a yes board all the time. Or you're just a yes board. It kind of gives them the idea that, yes, you do looking at things and what you're basing your decision on. You know, whether it's for or against or requirements of that.
You know, one of the answers that often comes up on these asks, and really, you really don't get a lot of variance requests in the Ag District anymore, do you? I think we pretty well took care of a lot of those. But basically the answer, take Lake Park, right? When someone asks for a variance in the Lake Park District, the answer is pretty simple. We have fill in the blank number of people who own property in the Lake Park District. It's not, you applicant are not the only one asking this question. We're gonna have to answer this question to everybody else who comes in. And we can't pick and choose, we have to defend why we said yes, as Richard's saying. In that discussion, if the answer is gonna be yes, I mean, and that's one thing too, but you do wanna talk about, here's what's unique about this. Here's what's different about this as we're doing it. That's where Richard's trying to coax that out of you when we're talking about findings of fact. You know, and he's just lobbing up, I don't know, maybe because the property was platted early, you know, in there. They're really just guesstimates at that point. It's really to try and get you guys to talk. And if you can't think of something, tell them no. I mean, and say, hey, guys, listen, I get it that this is a pain in your bottom, but the truth is that these were written for a reason. And if you don't know the reason, that's where I go back to the other point. You don't know the reason, or you can't think of a good reason why that's there. You know, sometimes you can put me on the spot, and I can try to explain why it would be there. I'm not going to give you oh, you better say no, otherwise you're dumb. I'm not going to say that in a meeting, but I will give you my best estimate as to why the rule was there. I will say I wasn't a part of the Lake Park discussions when that section was created. So I don't know every reason why that's all there, but I can tell you why other places have the rule. And you might wind up looking at it. You've been into this section, like Lake Park, that's been adopted for 8 years? Probably into 7 or 8 years. Probably is a time to take a look at is it what we want? And is it the way we want it? So let's keep that in mind too. Don't feel bad about, this really is something we need, and we need to amend our ordinances for. We're tired of issuing variances on this. Good discussion. Anything else for me? Good news. I'm out.
Well, if Luke is done, we'll move on to department reports.
Sir, the CO2 pipeline is meeting Thursday. We thought we'd be done by now, but the feds have put out some requirements, and the state attorney is coming to the meeting Thursday, and of course, Mandy Jensen is the zoning board representative. We'll keep plugging away at it. We really don't want to go away from the existing pipeline ordinance we've got. Perfect for natural gas. So we're looking at possibly adding under liquid pipelines, the hazardous liquid pipelines they call them, HLPs. Some of the same setbacks that we use in our CAFO for, you can't use the word safety in the ordinance because the federal organization does that.
Bob, I don't think your mic's on.
Pipeline meetings Thursday. Randy Jensen will update you at the next meeting. It's going to rain tonight. The rain's setting on the border right now of Kingsbury County, Brookings County. It's all the way up to Watertown and north. Good luck getting home, Luke.
Yeah, it looks like this is going to be it'll be fine if I get out of here in 1 minute.
Yeah, good luck with that. Richard is going to talk about at the county commission meeting that I was not at, Mr. Mills, who we turned down was it a variance or condition, he was one of the things for, he brought some documentation to the county commission to look at. The county commission directed the zoning, my office, county development office, to pass what Richard is passing out to you is what Mr. Mills gave to the county commission to take a look at. So what I would like for you to do is put this in that book. Remember that big book that Ray Lynn makes for everybody? Put this in that big book, and when we do our next ordinance review or next ordinance update, these are some things that it's from a concerned citizen, so we need to take them seriously and look at them and if it's something that you as a zoning board member feel is pressing, obviously you can bring it up at any time, but we encourage the public to give us feedback on our ordinances, and that's what I would consider this to be. Keep it in the book and back of your mind, and we will look at next time we update the ordinance. Richard, will let you continue.
Yeah, we're going to have a busy month here coming up in September the way it looks, so got several items on the agenda, and it's not the deadline date of next Tuesday yet, so But yeah, this is just some ideas that he had passed around. If you want to consider that, or good, bad, or otherwise, that's bringing it to your attention to bring back to as a possible amendment to the zoning ordinance, if you feel like it. So that's what we're always open to, suggestions and different things. If something needs to go on there, it's not working, we need to change it or delete it or add something. So it's a living document, the zoning ordinance is. So we have found a few things we need. We will be doing an ordinance update just for some minor wording things and different things in there for that. But otherwise, the zoning ordinance is working pretty good the way with the changes that we've done. So for the most part. So that's all that I have, and I think that's it.
Okay. Any need for an executive session? Oh, didn't think so. Motion to adjourn? Motion by Jensen, second by Troy, all in favor?
Aye.
Meeting adjourned.